Good afternoon, everyone, and thank you for joining us. I'm Ashley Craig. I am a partner in the International Trade and Logistics Group at Venable, and I am joined by my partner and colleague and friend, Liz Lowe, also a partner in the same group here at Venable. Today, we're going to be talking about trade and tariffs in the context of many things, obviously being driven by the current White House and its approach to utilization of those tools for a variety of reasons. Probably most importantly, we're going to focus most of our time on the pending high court issues and the possibility of a reversal of several of the Trump administration's approach to utilization of certain tariff tools. In addition to that, just as an overview, we will give you a review of how we've gotten to this point in time during the first several months and now almost an entire year of Trump 2.0. What the current state of affairs looks like regarding tariff utilization from the Trump administration's perspective, legal turning point, status of those challenges to the so-called IEEPA-based tariffs, possible outcomes, various scenarios, and then also probably most important and of interest to many, if not everyone on this call webinar, is the possibility of refunds of tariffs paid. Time permitting, we're going to take a little bit of a proactive approach and speculate as to what may be coming down the pike, 2026 and beyond, the remainder of this 2.0 administration. We encourage you to send questions our way as we move throughout. Both Liz and I will be monitoring the chat box, and we'll do our best to take those questions and answer them as we progress. We have about an hour. And we have baked in some time at the very end of the presentation for additional Q&A, time permitting. And if we do run out, we will make certain to field your questions and respond accordingly in writing post-webinar. Lastly, this is a CLE-worthy webinar, and about 30 minutes in, we will give you the CLE code and then also refresh it at the end of the presentation. So on that note, the way we're going to do this is Liz is going to jump in and provide commentary. I will provide color commentary throughout and also pepper questions as we go back and forth. Again, we encourage you to drop your questions and be as interactive as possible on this webinar. And having said that, I will tip it to my partner, Liz Lowe.
Great. Thank you, Ashley. Good afternoon, everyone, and thank you for joining us. As Ashley mentioned, we are going to start with a quick review of what has happened and where we are. This slide is a quick reminder of the various statutes that the president has relied upon to implement his expansive tariff program. On the left side of the screen are statutes that have been in place for decades. They clearly set forth the authority to implement tariffs. They were used during Trump's first administration and have been used by others and have withstood several legal challenges. So those statutes are Section 301 of the Trade Act that allows for the imposition of tariffs to address unfair trade practices by foreign countries. So think, for example, the China tariffs from Trump's first administration. And then the second is Section 232 of the Trade Expansion Act, which authorizes tariffs on goods that threaten U.S. national security. So steel and aluminum is a big one there. Both of these legal authorities require investigation by the competent agencies, generally involve public notice and comment. The process typically takes 8 to 12 months, although I will say in the past year, we have seen a significant speeding up of that time frame. So, for example, the copper investigation, from the time the investigation was initiated to the date that the tariffs were implemented, was under 6 months. So the administration is getting through these investigations faster than previously. On the other side of the slide, we have what Ashley referenced, the International Economic Emergency Powers Act, or IEEPA. This statute provides broad authority to the president to undertake a wide range of actions to address unusual or extraordinary threats to national security, foreign policy, or the economy of the United States. It does not specifically include the authority to levy tariffs, but it includes the authority to regulate imports. And that's one of the big issues in the Supreme Court case that we'll talk about. This is the statute that is typically used for our economic sanctions programs. So, for example, sanctions against Russia and Iran, those are implemented under IEEPA, under the president's authority under IEEPA. Prior to this administration, IEEPA in this form has not been used to levy tariffs. There are no similar procedural requirements like with Section 301 or 232, so no investigation, no notice and comment. Provides quite a bit of flexibility and leeway, which this administration has used to implement tariffs quickly. And the use of IEEPA in order to implement tariffs is the core issue that is currently before the Supreme Court.
Hey, Liz, if I may, just a question on that one. IEEPA, as you said, has become the tool that the administration likes to use largely because it's fast, it's quick, and it provides the administration with essentially exclusivity with regards to a tariff approach. I know we're going to get into it in a bit, but I'd be curious your take. Assuming that the High Court reverses and strikes down, I should say, more importantly, the use of IEEPA, that will impact how the administration goes about obviously moving forward, correct? And thus, it will be limited back to the more traditional routes that they pursued during the first term.
Yes, yeah, and I will raise that later as well. But yes, if IEEPA is taken off the table, that would have no effect on the administration's use of Section 301 and 232. And in fact, we would anticipate a ramped up, increased usage of those existing statutes in order to potentially replace what is here already under IEEPA. But yes, we would see a shift, I think, in the authorities used to reach the same goals, likely.
Great. Thanks.
Mhm. So, overview of the current tariffs. The president has used all three of the statutes on the previous slide in order to implement the tariff program. We did initially have, and I've presented on this topic quite a lot, so this slide has come with me through several webinars. And originally I had percentages here with the different tariffs, but they kept changing. The trade deals kept going into place. There were exceptions, so we took them out. I'm happy to answer questions about specific percentages separately if people are interested. But what we start with here, we've got the Section 301 tariffs. Currently, the only one that's in place right now are the China tariffs, again, left over from the first Trump administration. They were maintained, expanded on by Biden, and are still in place. Apply to most goods of Chinese origin. There are some exceptions there. The second 2 points there on the slide, you'll note they both say paused in front of them. These are part of an investigation regarding China's dominance in shipbuilding, cargo handling equipment, cranes. The investigation resulted in a decision to apply tariffs or service fees, as they were termed, for Chinese built, operated, owned vessels and certain Chinese cargo handling equipment. Went into place briefly. Some of them did in October, but have since been paused until November 10th, 2026 as part of the China deal. So they're on the books, but they're temporarily paused. Below that, we've got the Section 232 tariffs. As I mentioned, we've been seeing this used increasingly. We are seeing the timeframes for the investigations shorten. If IEEPA is ultimately struck down as a basis for tariffs, I think Section 232 is where we will see the most increase in activity. Right now, we've got several that are in place: steel, aluminum, and copper, autos, auto parts, trucks and parts, buses, kitchen cabinets, furniture, and then lumber and timber as well. That brings us over to the IEEPA tariffs that are currently in place. First, we have Canada and Mexico. These tariffs were put in place in March, related to border security and the fentanyl crisis. The Chinese fentanyl tariffs, those ones went into place in February, recently reduced from 20% to 10% as part of the China deal. And the reciprocal tariffs, those are tariffs that apply to virtually all of our trading partners. They range from 10% to, I believe, 41%, I think is the highest, maybe 49. Country specific, China right now held at 10%, down from that 125% earlier in the year. Those three, Canada, Mexico, China, and reciprocal tariffs, are what are at issue in the IEEPA litigation at the Supreme Court. This other two that are listed there, we've got an additional 40% tariff on Brazil based on free speech related concerns, and then an additional 25% tariff on India due to their purchase of Russian oil. These are also IEEPA-based tariffs, but were not specifically at issue in the lawsuit. A couple of other quick considerations here to flag. Retaliatory actions, primarily we saw that from China and Canada. Both have been scaled back significantly in recent months, so there isn't a ton of retaliatory action out there at the moment. There's been a lot threatened. We could see that pick up depending on how things shake out in the next couple of years. There is also what's been termed a quote-unquote transshipment penalty, which is really a penalty linked to misdeclaration of origin. So, for example, if a shipment of Chinese goods is routed through Germany, and then the importer tries to claim Germany as the country of origin, that would be a misdeclaration of the country of origin. It would trigger this transshipment penalty, which is an additional 40% on top of other applicable tariffs. That's also based on IEEPA. That comes from that authorization as well. And then finally, the last point I want to just make on this slide is that there are how the tariffs interact with one another is different. It depends on the tariffs and a lot of other factors. Some tariffs do what's called stacking on top of one another, so they are additive. So, for example, the China fentanyl tariff adds with the China reciprocal tariff, adds with the Section 301 tariffs on China. Those all add together. But there are some tariffs, like the Section 232 auto tariffs, which don't stack with other certain tariffs. So if you're subject to Section 232 auto, you're not also subject to the steel and aluminum or to the reciprocal tariffs. So there is some relief there in certain instances to keep these from becoming additive.
Hey, Liz, if I may, I know we've got a question that's just come in, but two quick points. I think you did an excellent job of clarifying that what is before the High Court, of course, pertains to IEEPA. There are some misperceptions out there that it's all tariffs that may be struck down. That obviously is not the case. And then also bringing up the question of transshipment. We've gotten you, I, and others in the group a ton of questions from folks that seem to indicate or think, giving them the benefit of the doubt, that, as you just indicated in your example, if you route from A to B, then B could be considered the country of origin and you minimize tariff impact. Most of the questions we get are innocent and they're not intentional, but there are those folks out there that are creative and are trying to mitigate to the best of their abilities, but that is just not the case. So, again, two important points. And a question that's come in is whether the case before the Supreme Court pertains to all IEEPA tariffs or just to China, Canada, and Mexico.
It's
So,
a great question. Um, the case is only looking at China, Canada, Mexico, and reciprocal. And I will, jumping ahead a little bit, but I do plan to talk about Costco's recent filing. As part of the arguments that Costco presented, they noted that other IEEPA tariffs that are materially similar, they are based in the same on the same legal basis, should also be struck down. So it is possible that additional legal action will be needed to effectuate any sort of striking down with regards to the tariffs that are not specifically named in the Supreme Court case. It shouldn't be a heavy lift if IEEPA is struck down as not being a valid basis for the tariffs. The other tariffs should not stand, but it could be procedurally that we need additional action taken in the event that the administration decides they're not going to proactively pull back the other IEEPA tariffs.
excellent. On the trade deal front, just a little bit of background. Beginning in the early part of the administration, there obviously was a great deal of attention paid under IEEPA to Mexico, Canada, and China right out of the gate. And then we saw, of course, additional tariffs applied, the reciprocal tariffs applied, pressure being brought up on our trading partners. The administration announced that there would be many, many, many deals with every single trading partner over a very short period of time. That has not materialized. What we have seen are a series of finalized deals, as you can see in front of you, ranging from the EU down to Malaysia. Those were all initially framework deals, then followed with post-deal months of negotiation and agreements. Take, for example, the UK. That one was quote unquote finalized around May, June, but it predated that. And we also have a series of framework deals, as you can see from Argentina all the way to Vietnam. Again, not the number that the administration was indicating back in the early part of the spring, but there are still negotiations that are ongoing across the board, as we were being told by the administration itself. We also have temporary deals. Liz referenced China and the fact that the Section 301 so-called ship tax has been suspended, as well as some of the applications to gantry cranes, ship-to-shore cranes, and other intermodal equipment coming out of China. More details to be worked out with regards to the PRC and the U.S. deal. We do anticipate that there will be more coming. And then we need not forget that USMCA already has baked into it, going back to the first Trump term, a revisit by the three parties that is due next year. We also know that the administration has been pushing to expedite that USMCA review, notwithstanding that the administration during Trump 1.0 said that the redo of what was, of course, NAFTA was the best trade deal in the history of the United States. The indication now is that they don't really like it and they want to revisit it, and we're not quite certain which direction they're going to go. Although the administration has not granted any sort of pure relief as they did in the first go around, meaning Section 301, where there were exclusions granted if you met certain criteria, there have been certain sectors that have seen and benefited from agreement. In particular, you'll see here investment, reshoring in the United States. Pharma and autos are the two that have been indicated by the administration as champion, if you will, examples. Also, certain exemptions for certain agricultural products from the reciprocal tariffs. And then lastly, Section 301 product exclusions that have been extended, going back to the first term, now extended, again, certain ones through November of 2026, November 10th in particular. So we understand that the administration is welcoming. In fact, we've had folks that have gone in and made a case that they should be granted some sort of relief. Typically, what the response is from the White House is, that's fine, reinvest or invest, reshore in the United States, bring things home, and we'd be happy to sit down and talk about some sort of relief. Again, pharma and autos are two examples. So keep eyes on continued negotiations. We do anticipate going into 2026 that there will be additional deals, as well as the framework deals outlined above on this slide coming to, if you will, a bit more refinement.
And just to flag a question we get often with regards to the framework deals, they aren't final yet. So the potential tariff relief that is talked about in those framework deals is not official until it is issued in a Federal Register notice and incorporated into the harmonized tariff schedule. There is also this Annex 3 that includes all of these products that could potentially get relief depending on whether a deal goes into place or not. Those are just suggestions. They are not official. There is not official relief or exemptions for anything until it moves into that Annex 2 and it's reflected in the harmonized tariff schedule. So just something to keep in mind when you're seeing news alerts about framework deals where, such and such country has negotiated a 10% tariff. That's all well and good for them to say that, but it needs to be reflected in our regulations first.
Liz, that's a great point. Just very quickly, the administration oftentimes speaks before finalizing anything. And we saw that with the so-called China ship tax. There was an agreement reached in principle coming out of the U.S. and Chinese negotiations. The administration indicated that the ship tax would be suspended, but it took a number of days, frankly, over a week, before USTR could go through the administrative process. Since it was a Section 301 determination, they had to reverse it, which typically does not happen. And they did that very quickly, I think, in an unprecedented manner. But there was still a period of time, notwithstanding what the administration had said, and the implementation of, if you will, the reconsideration of the suspension of that tax. So same thing applies across the board. That's a very good point to stress. Thank you, Liz.
So turning to the current challenge to the use of IEEPA to implement tariffs. The case that ultimately reached the Supreme Court was a consolidation of cases from the lower courts. And while there are various arguments that are presented in the cases, the primary legal argument of the plaintiffs is that IEEPA does not authorize the imposition of tariffs. Specifically, while the statute does authorize the president to regulate imports, i.e., put import bans in place, trade quotas, etc., the authority does not extend to the implementation of a tax on imports, taxation being an authority that is reserved to Congress. The government, on the other hand, argues that Congress can delegate its authority, can grant the president limited taxation authority, the authority to tariff, and they have in Section 301 and 232. And that the term regulate imports includes the specific authority to levy tariffs. So even though IEEPA does not say anything about tariffs, the government argues that regulating imports covers that. Importantly, which we addressed a couple of times, but just to underscore it again, this litigation only addresses the use of IEEPA and only certain of the IEEPA tariffs. It does not touch on Section 301 or Section 232. Those are separate legal authorities. So far, the plaintiffs have been successful from a substantive standpoint at both lower courts and at the appeals courts. Interestingly, however, while the Federal Circuit affirmed the lower court's findings with regards to substance, so the Circuit Court agreed that the tariffs were invalid under IEEPA, it did vacate the lower court's permanent injunction, which basically said the administration cannot enforce or implement any further tariffs under IEEPA. But the Circuit Court remanded that back, saying that the lower court needed to consider the propriety and scope of that injunction. So whether a universal injunction is appropriate or whether perhaps relief should be limited to those who brought the case as opposed to everyone who might otherwise be eligible. So this raises questions on what remedies may be available and to whom if ultimately the Supreme Court rules in favor of the plaintiffs. For now, the tariffs remain in place as is. We are seeing, as we'll talk about later, continued increased enforcement from customs. They are proceeding as if the IEEPA tariffs are valid and will continue to be valid. The Supreme Court took the case on an expedited basis and had oral arguments on November 5th. There is speculation that the court will issue its decision by the end of this year or early next. But an important thing to keep in mind is that the court is not bound by any date other than the end of its terms. So if it so chose, the court could hold off on ruling on this issue until May or June of 2026. This is an important factor for importers in deciding what steps you might need to take or want to take in order to preserve your rights. There are several potential outcomes that the Supreme Court could reach in this case. We've divided it into sort of three primary categories here, all of which have a lot of variations that we don't have the time to get into today. But just from a high level, first, the court could overturn the lower court decisions, uphold the use of IEEPA for tariffs, and everything would just remain as is, business as usual. Second, the court could decide some issues and remand others to the lower courts. Frankly, in my personal opinion, I think this is the most likely result, is that the court will rule on the question of the use of IEEPA and whether it is legitimate, but will likely not make any ruling with regards to remedies, injunctions, refunds, and all of that will be remanded to the lower courts, which of course from a timing perspective then adds on more time, right? So if the Supreme Court comes and says IEEPA is illegal, but we defer back to the lower courts to figure out what that means and what to do, that's additional time added on before we have clarity as to whether or not refunds are available, how to get them, who is eligible, etc. The third option is that the court simply affirms the lower court rulings, maybe addresses the issue of the scope of remedies. Again, I think it's unlikely that the Supreme Court itself will make any proclamation with regards to how refunds should work, but they could opine as to the scope of the remedies available. There is a question with regards to the impact on other tariffs, which we've sort of touched on already. The other IEEPA-based tariffs could either be voluntarily withdrawn by the administration or will likely face legal challenges to get those taken down as well. No direct impact on Section 301 and 232, except that we expect those will be used a lot more. So no relief on those, but perhaps an increased use. Turning to how the refunds themselves might work, there is a possibility that the court will rely on recent precedent, and either the Supreme Court or one of the lower courts, if it's remanded, that limits relief only to the named plaintiffs, meaning that only the entities that brought the case could be entitled to relief. I will talk a little bit more about that. Another possibility is that refunds are available to anyone provided that they use the statutorily established process and abide by the deadlines that are set forth in the statutes and regulations. For example, filing a post-summary correction, a PSC for unliquidated entries, or a protest for liquidated entries, which has to happen within 180 days from the date of liquidation. It is important that importers keep track of liquidation dates for their entries because and I won't speak for Ashley, but I do think he is of the same opinion that it is unlikely that this administration is going to provide any leeway. If you have missed the statutory deadlines during which you are entitled to request a refund, in any case with CBP, right? If you have a change in tariff classification or country of origin that was misdeclared and you're going back and you're correcting it and requesting a refund, there are set timeframes for that. If you miss those set timeframes, the administration could say you're out of luck. Even though the Supreme Court said these were illegal, you missed the timing. So timing becomes crucial here. Now, some parties, for example, Costco, have taken proactive steps to secure potential refunds in the event that the Supreme Court rejects the government's position on IEEPA. And they've done that by filing at the Court of International Trade. The Costco complaint was filed for several reasons. One is they want to address the risk that those who do not have a judgment for relief might not be entitled to relief, which is that first point. Sorry, trying to get a laser pointer. This first point here on the slide that only the plaintiffs could potentially be eligible. So they are trying to make sure that they are holding their place by filing a suit. They become a plaintiff. Costco also has entries that are going to start liquidating soon. There are probably a lot of people on this call who are in the same boat. So their 180-day clock is going to start, and we don't know when the Supreme Court is going to rule. Also, Costco, along with several others who have filed similar complaints, have asked Customs for an extension of liquidation and been denied. So Customs has already said, no, we're not going to give you extra time, which is what I think Ashley and I would have expected. And so they are putting a flag down by filing a case saying we want relief as well. Costco's not the only one. Revlon, Bumblebee actually filed before Costco. Obviously, they are probably the largest volume importer, biggest name to have taken this step. But there are more than 70 companies at this point. It might be even more than that stat that I have that have decided to do similar lawsuits. If you will remember, we saw a similar situation with the Section 301 litigation that started back in 2021, where some initial parties filed and then a lot of other importers went ahead and filed their, protective complaints in order to make sure that they were also in line to get refunds.
Hey, Liz, if I may, you obviously rightfully brought up Costco and the others, and it's something that we're getting questions from left and right now. And I think you did a great job of saying it's a proactive measure that the companies have decided to take. It helps to position them in case the court, as you said, decides that it's only those that are the plaintiffs. So my take is that the recommendation is obviously it depends on the individual importer, but this is the time to give consideration to potentially doing what Costco and others have done, and filing at the CIT. So obviously, if folks online have questions, they can reach out to us, and we could be happy to have that conversation offline. But it is definitely worthy of consideration. The other thing I would note is, I think everyone on this call is involved in import operations, supply chain operations, etc. And so you've interacted with CBP. And over the last almost now 12 months, we've seen the agency being stretched, pulled in different directions, being utilized for a variety of non-trade related initiatives, if you will. So if in fact we find ourselves with the High Court striking down IEEPA, um, that's only going to put more pressure on CBP and the Treasury to move forward in terms of the potential refund activity. So again, now's the time to give thought to whether you want to take an action like Costco. So thanks, Liz.
Um, so that was a great segue and covers some of the stuff I was going to touch on here. So refund readiness. In the event that the Supreme Court does strike down the tariffs, you need to be ready to act fast. So this is a list of some recommendations. The first is tracking your liquidation dates. You can get that from your customs broker. So ask your customs broker to provide you a copy of your ACE data with the anticipated liquidation date and get updated versions periodically that reflect the actual liquidation date. From that date, you calculate 180 days, and that's your protest deadline. So something very important to keep on top of. If the Supreme Court issues a decision and you still have unliquidated entries, you should be able to address those via a post summary correction. Again, assuming that the courts don't say that this is limited only to the plaintiffs, but if it is broader, or if you go in and you file a CIT matter and it proceeds the way you want it to, if you've got an unliquidated entry, a PSC is the way to go. You can request suspension of liquidation. It is discretionary from CBP. I think that it is a gray area as to whether or not a pending Supreme Court case is sufficient justification, frankly, for CBP to suspend liquidation. And as we have now seen in multiple occasions, Customs is just denying these requests. So it's up here for completeness, but not realistically not an option. Filing a protest in a timely manner. Keep track of those dates, get protests in before the 180 days. We file protests regularly on behalf of clients. I assume we will be doing quite a bit of that. The last point here, frankly, probably I should have moved it up to the top of the slide, because this question of filing a timely CIT suit is going to be one of more urgency now. We've had folks asking about whether they should file suit at the CIT for a while, and for a while it looked like things were going to wrap up in time such that we weren't triggering all of these deadlines. And there wasn't a ton of indication that it would be limited just to the plaintiffs. I'm not sure right now that there is, but it's definitely a possibility. As we get closer to these deadlines, as the thought is out there that the Supreme Court could take longer, now we are seeing, again, more people going, it is making more sense to take that step. Litigation is litigation. It is not necessarily an easy thing to undertake, but this is the time, as Ashley mentioned before, to consider it, to look at, what is the volume of potential refunds that you have at stake? When did your entries first start coming in? Are you at the later end and you've got more time? Or were you paying starting on February 4th and you're starting to run up against your liquidation dates? All things to consider, and things that we are happy to discuss with you. Just want to quickly do this one as well. Basically everything we've talked about already, but so everybody has the dates here in their minds. These are the three sets of tariffs that are at issue in the Supreme Court case. They are also three sort of earliest ones of the IEEPA tariffs. The others came later. China fentanyl tariffs went into effect on February 4th. They will start liquidating. The earliest ones will start liquidating on or around December 15th. The first protest deadline for those earliest ones will be June 13th of 2026. So if the Supreme Court decides to wait to rule until May or June of 2026, you are right up against that deadline there from a protest perspective. So not much wiggle room. Canada and Mexico, you've got a January 12th date for when liquidation is likely to begin, July 11th for the deadline. The reciprocal tariffs, there's a bit more time, right? We've got February 10th for when we start seeing some liquidation, August 9th for the protest deadline. Big caveat here, which of course is in smaller type on the side, but these dates are based on the typical standard liquidation time frame. Customs can liquidate things earlier. Informal entries are liquidated earlier. The 180-day protest window that stays the same, but when liquidation occurs can shift and depend on your supply chain and the types of entries. So again, very important to get that information and track it. And I will pause right now to say that the CLE code is Tariffs 2025. Before we move away from this, Ashley, was there anything?
I was just going to underscore what you have already touched on, which is, again, this is the time to kind of get everything in order. Um, Working with your broker or your brokers, because I know several folks probably on this call have multiple brokers, is extremely important, always is. So a plug to sit down and coordinate with your customs broker. And obviously, you can reach out to counsel as well. It will be a consolidated and a coordinated effort if this does come to be, which I think we both have a agreement in principle that the high court is likely to break against the administration. It's a question of degree. I was going to put you on the spot, and I guess I am going to do that now, Liz, and say, what is your gut tell you in terms of the potential for the high court to go against the administration here? Don't feel like you got to put an actual number on it, but if you want
Uh,
to, go ahead. You feel very confident, so.
Um, well, what I have been saying to folks in general is that before the oral argument, I was giving it a 60-40, 60 in favor of them striking down the tariffs. The oral argument, I mean, really saw across party lines, there being skepticism of the tariffs and concerns about what this type of expansion of executive power means with regards um, to things that are traditionally delegated to Congress. And so after the oral arguments, I adjusted, and I'm now at around a 75% chance that I think that the court will strike down slash limit the use of IEPA in some manner. What that looks like is still, I think, quite a bit of a question.
But I think the one thing that we can agree on is that the administration has been adamant in saying we need this authority. And it's not a question of separation of power between the branches. This is, in their view, something that resides within the executive. And again, they've used it for a variety of reasons, ranging from national security to fentanyl, as well as, of course, we've seen it with regards to Brazil in a purely political manner. So a lot at stake here. And again, I think the only agreement we have is that there will be a lot of attention paid on this. And then there's this question that you actually posed earlier today, which is what happens with the White House if they decide that they just want to, frankly, disregard what the high court says? I mean, everything is upside down in this world. And we've seen the administration approach things, including the application of IEPA as they have, in a very unorthodox way. So there are a lot of questions that are out there. But again, the takeaway here is you just heard from Liz. These dates are important. This is the time to get your ducks in a row and spend some time with your broker and counsel and others.
Um, there are several questions, although it might be better to wait to do those at the end. Um,
Yeah.
so yeah, we'll come back to the question. Please keep sending them in. We will get to them. We should have time for that. I'll get through these next couple slides pretty quickly. Um, so while the IEPA case is as we've discussed, potentially a significant turning point in the tariff landscape. We really don't want to lose sight of the other tariffs that might be on the horizon. Tariffs are not going away entirely. So this slide just has sort of an overview of potentially forthcoming tariffs. As I've mentioned, I think a couple of times now, Section 232 investigations, I mean, they are coming in rapid fire. I feel like for a while it was every day there was a new Section 232 investigation. We've got a whole bunch that are open still. Some the investigation has been concluded, like the pharmaceuticals, but no action has been taken yet because the president just says he's working on deals with various pharma companies. Others are still open and in progress. If IEEPA is struck down, again, this is where I think we will see a huge surge of activity of things moving over into the Section 232 space. Section 301, several investigations open for Section 301. So China, for example, even though we've just reached a deal with China that reduces some of the tariffs, reduces the fentanyl tariff, keeps the IEEPA tariffs at 10%. We not exactly simultaneously, but not too far off from one another, initiated an investigation into China's compliance with the Phase One trade deal from Trump's first administration. So there could be more coming for China as well. The secondary tariffs, I did just want to flag now, if IEEPA is struck down, these are all based on IEEPA. So again, they should either the administration should back away from them or they are likely to be subject to a challenge and ultimately struck down. These are tariffs where one country is penalized for engaging with a third country, so not penalized for their own actions towards the United States, but it's sort of a further attenuated connection. Iranian oil, Venezuelan oil are ones that are out there but have not been used. And then there have been a bunch of threats as well in that space.
If I may, one issue that's popped is with regards to India and obviously the high tariff rate that has been attached to it, and the administration has flagged that is in response to India's continued quote cooperation with Russia in oil consumption. We've heard from many now that folks moving product out of India are now in a very awkward situation. Before the tariffs were applied at such a high rate, people were ramping up and looking at the shipping cycle and entering into service contracts with carriers. And now that the volumes have dropped to the United States, we have heard that shippers are in a very difficult position. Carriers have within their service contracts essentially liquidated damage provisions that kick in if you don't meet a certain amount of volume. So just a little quick footnote, you should take a look at, if you are a shipper as well as a carrier, your service contracts and from a holistic perspective, look at India as an example, because it may not only just be India. We could see this kind of ripple throughout, given the high rate of tariffs that the administration has imposed on most of our trading partners. So it's not just purely the application of the tariff. There are other ramifications that, from a supply chain perspective, we're starting to see ripple through the supply chain. So thanks, Liz.
So just a quick enforcement overview. Regardless, again, of what happens with the IEEPA tariffs, we do expect CBP's directive to prioritize tariff enforcement to continue. It will shift likely to focusing on Section 301 and 232. You can see we are talking about a lot of money from January to October. Customs collected $238 billion in tariffs, taxes, and fees. I will say that about 35 billion of that was collected via customs enforcement. So customs audits or customs entry review, where they identified underpaid duties and enforced and collected it. And so on top of that 34-ish billion that customs collected, they also issued penalties and liquidated damages. So enforcement is still going strong, and I don't think we anticipate that going down at all, even with if IEPA is struck down. What CBP looks for is red flags to help identify potential tariff evasion. So, for example, if an importer's activity changes, so if all of a sudden you change your tariff classification or country of origin, or your values change drastically, that's something that could heighten scrutiny. It's not to say that you shouldn't or can't make those changes if they are legitimate and in line with the applicable regulations, but we do strongly recommend in this enforcement environment having either a legal opinion from Customs Counsel or obtaining a binding ruling from Customs to back up and support any such change, so that if Customs asks why you've made such a change, and obviously in their mind they're thinking it's tariff evasion, you can show that it is not. We have seen, as Ashley mentioned earlier, an increase in tariff evasion schemes such as double invoicing. So suppliers offering to issue two invoices, one for customs valuation purposes and another that includes, management fees or inventory control fees. That's not permissible under customs law. We're also seeing a lot of transshipment and misdeclaration of origin type schemes. DOJ is well aware of this activity. They are part of a cross-agency task force that has been directed to address tariff and trade fraud. And the agency is actively using tools like the False Claims Act to go after folks that are evading tariffs, and the penalties under that can be pretty significant. So something to keep in mind, and that will take me to just the last slide, which is a quick reminder, and then we will get to these questions. There are quite a few piling up here. There are legitimate steps that you can take to mitigate the tariff impact. Some are more applicable, frankly, for Section 301 and 232 tariffs than they are for the IEPA tariffs. So it is still important to look at your supply chain, look at your customs compliance, and determine whether or not there are strategies that you can employ to reduce the tariff impact, mitigate the tariffs. So, for example, taking a look at the country of origin, seeing whether sourcing or some processing can be shifted to a third country enough that effectuates what's called a substantial transformation. Taking a look at valuation and seeing whether you are eligible for the first sale rule, which can result in a lower declared value. On the classification side, this becomes much more important when we're talking about Section 301 and 232, which are tied to tariff classification numbers, as opposed to just the reciprocal tariffs, which are, everything that comes from XYZ country. So, making legitimate changes to a product that moves it from one tariff classification to another. These are things that can be considered. Taking a look at Chapter 98, there are some provisions there that can provide either full or some limited relief, and then USMCA eligibility. The other things I think are relatively self-explanatory. Engage with your representatives. Make sure that folks know how this is impacting you. With that, we only have about 6 minutes left, so maybe we should turn to questions.
Yeah, just very quickly, I just want to underscore that a lot of this, if not all of it, is not new. And those of you on the call that are well versed in import operations have probably already been doing this. And unfortunately, unlike the first term, meaning the first Trump term, given the wide holistic application of tariffs, it's not as if you can move sourcing from A to B. That simply is not an option. So that underscores everything that Liz has just talked about, and that's in front of you on this slide being paramount. So if you're not doing it, now is definitely the time to start looking at these potential mitigation strategies. So, um, with that, we've got 5 minutes, it looks like, Liz, and I don't know where you want to start. But
We could start at the top. We'll get through what we can. There are some here that we will follow up in writing separately because they're more appropriate to be discussed offline. There is a question about whether there is still an opportunity to request the addition of further agricultural products being added to the exemption list. Um, this is where I would absolutely direct you to your government relations team. We have one here. If you don't have one in-house, uh, these lists, these exemptions, these are policy decisions that are being issued by the administration. The only way to really try to get in there is through political maneuvering, and I do have to say it's quite difficult at the moment. But that's not to say that there isn't potentially an opportunity, but that's the way to go about that. There is not a set legal process or administrative process that has been set up to request additional exemptions. Um, the next one is the extended 301 exclusions. Everything that was current that had been, as of October of this year, was still subject to an exclusion. Those exclusions were all extended. The list of exclusions is available in the harmonized tariff schedule. If this person wants to shoot me an email, I'm happy to send you a link to where those are listed.
hey, Liz, real quick, just to supplement what we were talking about in terms of government relations, trade associations can also be effective. At the beginning of this administration, the White House frankly didn't want to meet with trade associations. They welcomed individual engagement. They softened that. So those of you that are active in trade associations, and there are many out there that have been pinging away on trade policy, that's also a potential avenue for you if you're small and medium and you don't have the capability to outsource government relations or you don't have the internal capability, lean on your trade associations.
Absolutely. Um, so a couple of interesting questions here. I'm going to go a little bit out of order. Question about filing protests before entries are liquidated. Um, the protest filing system should kick you out and not allow you to file a protest if the entry is not liquidated. So I'm that doesn't seem to be an option. We have heard rumblings of what's been referred to as a protective protest. So basically, once your entry liquidates, filing a protest saying we intend to protest this based on the results of the Supreme Court um, case. There's no precedent for that. So, I don't think it's necessarily a bad thing to do if we're trying to do belt and suspenders to go ahead and do that. Uh, but it's not something that I would rely on as guaranteeing that you're going to be able to get a refund back. So that could be the rumblings that this person is hearing about as these sort of so-called protective protests. But again, I don't think it's harmful, but it should not be the sole thing that you rely on. Um,
We have 1 minute.
Another, yeah, 1 minute. So maybe Ashley, for you, if you want to take this one, if the court rules for the plaintiffs, how will that affect trade deals signed that relate to reciprocal tariffs?
That's a very good question. And I think there's a big question mark right there. As Liz indicated earlier in her overview, it's important to realize that what is before the court is a slice of the tariff approach that the administration has taken. We have heard, and I think this is also in part why many of the trade partners out there have taken a pause and they haven't reached a decision or an agreement with the administration, everyone has eyes on what is the Supreme Court going to do, and how is that going to impact the potential negotiation or need to negotiate. So, a big question mark in my view. Again, something that we need to keep eyes on. But we will all be very focused on what the High Court does, and hopefully sooner rather than later. As Liz said, if they do wait to the end of that term, it's going to create a lot of curiosity and frankly, tense moments for a lot of importers looking at liquidation. Um, would remind everyone that the CLE code is Tariffs with an S 2025. We have a ton of questions, so thank you very much, folks, for participating and being active. As Liz said, we will do our best to follow up in writing, and we'll work with our marketing team here at the firm to help push that out. This has been recorded and will be available for download and streaming. Let me thank Liz for an outstanding job. Very thorough, lots of moving parts right here, and you did, as usual, an outstanding job of running it to ground and helping to simplify what is a very complex situation here. So, on that, thank you, Liz. Thank you to our comms team and marketing team at the firm, and thank you all very much for participating today. And something tells me you'll be hearing from us soon. This is one issue that's not going to go away anytime soon.
Thank you all.
Thank you.